It is 9:35. I thought this was an interesting case that came up. I remember reading about it and thinking, well, there has to be some level playing field here. And quite often, still in this country, I think employees are they get short-sheeted a lot. But the highest court says employers now, who once thought that family matters didn't matter in the workplace, well, you're going to have to rethink that now, because the landmark federal court decision says workplaces are obliged to accommodate reasonable child care-related requests for their employees. The requests for child care accommodation stem from genuine need and are not simply a lifestyle choice. I think that's fascinating. Stuart Rudner joins us, an employment law specialist at Miller Thompson. How are you, Stuart?
I'm great. Thanks for having me on.
Always good to chat. I'm fascinated. I think the pendulum has really gone the other way from when I started in this industry, hasn't it?
It absolutely has, and you made a point in your intro about how sometimes employees do still get the short end of the stick, and things like human rights legislation were put in place to protect employees from discrimination. Historically, women were disadvantaged, certain groups were disadvantaged. That was the intention. I don't think anyone who took part in bringing human rights legislation into place contemplated that child care obligations would become a protected ground.
Now, forgive me for being skeptical, but it's not my first rodeo. Is this not going to then, from an employer taking a look at a young parent and saying, maybe not?
Absolutely, and I made that point to somebody yesterday. I think that's the unfortunate reality is before this even came to pass, when employers were looking at candidates and they'd see a woman of childbearing age and they'd think, well, I might be looking at a pregnancy leave, a parental leave, someone who has to leave every day on, it's right on time to go look after their kids. There were a lot of employers who were already shying away from those candidates, and I think, unfortunately, this is going to make it even harder for women of that age group to get jobs.
So that's I would call that unintended consequences.
I think it's absolutely unintended, and of course, no employer is ever going to say that. But I think that's going to be the reality.
So who's the onus on here? Is it still on the onus on the employee to prove to an employer that, look, I've done everything I can, and I just can't be here today?
It absolutely is. I mean, when an employee requests accommodation, and the way this reading is to be interpreted, it's no different than somebody with a disability saying, I need some sort of accommodation. So the employee would have to go to their employer and show a genuine need. I mean, this isn't carte blanche where every employee that has kids can now dictate their hours of work.
Right.
But they'd have to go show a genuine need. In this case, the woman called evidence, including, I believe, somebody from the daycare talking about the hours and availability. They'd have to show a real need, and then what's supposed to happen after that is the employee and the employer engage in a dialogue, and the union as well, if there is a union there, and try to figure out what the accommodation options are. And then it's up to the employer to assess them and figure out if they're feasible. And the law requires that they accommodate to the point of undue hardship, which is a term that is deliberately vague, but the primary consideration is always going to be cost.
Stuart, I got an email from Vic who asks you this question. Having children is a choice, so why should an employer be punished for your choices?
And Vic is certainly not the first person to make that point. I think it's a fair point. I mean, this is different than somebody who suffers from a disability, who presumably did not choose to. You're right. It's somebody who made a choice to have kids, and many of us have done it. I've done it. We've got kids at home, and my wife and I figure out how to make it work, even though we both have busy careers. So I take the point, but that's not the way that the courts and the legislature have chosen to go. They've chosen to put more of an obligation on the part of the employer. So
we're leveling the playing field. Or the attempt is to level the playing field.
That's the attempt. I mean, look, some people will certainly say that the spectrum has shifted totally the other way to protect employees too much. I think I work with a lot of small and medium-sized businesses, and I know that it's hard. It's hard to run a business and make a living when the government and legislation and the courts put all of these obligations on or burdens onto the employer, which adds to their costs, adds to their work, and makes it very difficult just to go and run a business.
Wow. Is this going to be warmly received corporately, Stuart? Are employees going to say, finally?
Well, it's interesting. I mean, certainly employers are not going to be all that happy for obvious reasons. What I find interesting, though, I was listening to a talk show radio yesterday in Toronto talking about this case, and every individual that I heard over about 10 minutes was also quite upset by this. And one person made the point that the woman in this border case who got the ruling is probably now the least popular person in that workplace.
Yeah. And by the way, we didn't mention that case off the top. It involves Canada Border Services Agency and a woman who was put in irregular rotating shifts. And after she had children, that just wasn't working for her. She wanted, I don't know if it was 9 to 5, but she wanted a steady shift so she could plan her life.
Well, exactly. And I mean, the impact here, I mean, first of all, cost is always a factor. The other impact is on the other workers, right? So somebody else now presumably is going to have to get the quote-unquote worst shift.
So if I don't have kids, I had a 9 to 5. Now I'm the one that's getting the irregular rotating shifts?
That might be the accommodation. And in that case, there was a union there, a collective agreement, so it might even impact people with more seniority.
Wow. So we have these changes now, but it still hasn't been ironed out. There still has to be a lot of work done on this. There's a lot of wrinkles in this story.
Well, that's what keeps guys like me busy.
Well, I'll let you get back to it. Always good to chat. Thank you.
Thanks very much.
Take care. Bye. Stuart Rudner is an employment lawyer at Miller Thompson in Toronto. The High Court said employers must accommodate reasonable child care requests. Agree? Disagree? Have you found it difficult, impossible? Keep in mind, the other end of this spectrum is a day like tomorrow when there's going to be so much snow planned. What do we do with the kids? So does one parent just get to stay home because of bad weather and employers have to accommodate? You see, there's a whole lot of meat on this bone. We'll take your thoughts in a minute.